Companies Act 2013. Basic functions of government. 1. Legislation. 2. Executive. 3. Judicial. Law, rules and regulations. Substantial law. Business law. Environment law. Intellectual property law. Corporate law. Administrative law. Family law. Procedural law. Civil Procedure Code 1908. Criminal Procedure Code 1973. Indian Penal Code 1860. Civil offense. Civil law is initiated by the aggrieved individual or organization, or also known as plaintiff. In case of civil law, to start a case, the aggrieved party needs to file a case in the court or tribunal. Criminal offense. The government files the petition. In case of criminal law, as per criminal law, to start a case, a petition cannot be filed directly in a court, rather the complaint should be first registered with the police and the crime needs to be investigated by the police. Thereafter a case can be filed in the types of business. Business, lawful activity carried by group of people for earning profit. Sole proprietorship business. Partnership business. HUF business. Company. The Companies Act. History of Companies Act in India. In England, the Joint Stock Companies Act was passed for the first time. Under this act, a provision was made for the registration of companies. In the year 1850, taking the English Joint Stock Companies Act 1844 as a base, a provision was made for registration of joint stock companies. In India, after this the Joint Stock Companies Act was passed in India in the year 1857. Under this act the concept of limited liability was introduced for the first time in India. Thereafter the Companies Act was passed in the year. The act was later replaced by the Indian Companies Act. After independence, the government appointed a committee under the chairmanship of Shri H.C. Babha in the year 1950 to revise the Indian Companies Act. Of the committee submitted its report in the year based on the recommendation of the committee and the provisions of the English Companies Act 1948, the Companies Act 1956 came into force on April 1. The Indian Companies Act 2013 replaced the Indian Companies Act. The Companies Act 2013 passed by the Parliament on the basis of recommendations given by Irani Committee has received the assent of the President of India on August 29. The Companies Act 2013 has been notified in the Official Gazette on August 30. Company. Meaning of company: the fact or condition of being with another or others, especially in a way that provides friendship and enjoyment. I really enjoy his company. The concept of company or corporation in business is not new but was dealt with in 4th century BC itself during Arthashastra days. A company form of business has certain distinct advantages over other forms of businesses like sole proprietorship, partnership, etc. It includes features such as limited liability, perpetual succession, etc. Sector 1. Title, extent, commencement and application of Act. Title: The Companies Act 2013. Extent: whole of India means including Jammu and Kashmir. Commencement: Sector 1 came into force at once and other provisions on different dates by notification. Application: companies incorporated under this act, insurance companies, banking company, companies producing and supplying electricity, companies regulated by special act, entities as notified by central government. Application: companies incorporated under this act or previous company law, e.g. Reliance, Bata. Insurance companies, e.g. Max Life, Religar Health Insurance Company. A banking company, Yes Bank, Union Bank of India. A companies producing and supplying electricity, e.g. Reliance, Adani. A companies regulated by special act, e.g. RBI, SBI. Entities as notified by central government. Sector 2 definitions. Sector 2 of the Act defines various terminology used in the Act. The different words are defined under Sector 2(1) to Sector 2(95), 95A. Here we will start with the definition of company and the remaining words. We'll define as we go deep in detail of the Act. The word company, derived from. The word company is derived from the Latin words come with or together, and panis bread or meal, and originally referred to an association of persons who took their meals together. Term company has been defined under Section 2(20) of the Companies Act as per this. Company means a company incorporated under Companies Act 2013 or under any of the previous laws relating to companies. Definition of company by Lindley. Definition of company. Professor L. H. Haney defines company as an artificial person created by law having a separate entity with a perpetual succession and a common seal. Chief Justice Marshall defines a corporation as an artificial being, invisible, intangible, and existing only in the contemplation of law. Characteristics of company. Features advantages of incorporation. Separate legal entity. In the landmark decision of Salomon v. Salomon, 1897, AC 22, it was held that a company has a corporate personality which is distinct from its members or subscribers. In case of Tata Engineering and Locomotive Company, Limited v. State of Bihar, the Supreme Court described the legal status of a company as an incorporated association before law is equal to a natural person and has a legal identification of its own. Perpetual succession. In Punjab, National Bank v. Lakshmi Industrial and Trading Co. Ltd. It was held by the Allahabad High Court that perpetual succession means that membership of a company may keep on changing from time to time, but that does not affect the company's continuity. A company has a perpetual existence, i.e., it has no soul to be saved or body to be kicked. Common seal. It is considered as the official signature of a company. But now by the virtue of 2015 amendment to the Companies Act, a company may or may not have a common seal. Sector 21, any key managerial person or officer authorized by board. Sector 22, the authorization shall be made by 2 directors or by director and company secretary. Limited liability of members. 3 types of liability: limited, unlimited, and by guarantee. Transferability of shares. Section 44 Companies Act of the Act declares that the shares or debentures or any other interest of any member in a company shall be a movable property that can be transferred in the manner provided in the article of the company. Capacity to sue and be sued. Company not a citizen. According to Citizenship Act 1955, only a natural person can be a citizen of India. Not a juristic person will be considered as citizens, same stated by the Supreme Court in case of the State Trading Corporation of India Limited versus the Commercial Tax Officer. Even though the company does not get the citizenship status of a country, it still can get a residential status. Royal Chartered Company. The company which have formed and incorporated under a special charter granted by the King or Queen, e.g. East India Company, Bank of England. B. Statutory company. These are companies which are created by means of a special act of Parliament or any state legislature, e.g. RBI, Railway, National Highway Authority of India. C. Registered company. A company formed and registered under Companies Act 2013 is called registered companies. Registered companies are further classified as under on the basis of Constitution. S. Associate. An associate company is a corporation in which a parent company possesses a stake. Thus, an associate company may be partly owned by another company or group of companies. A company will be treated as an associate company of another company if the former is having at least 20% of the total share capital of the latter, or 2. Having significant influence over the latter's decision-making process under an agreement, or 3. Both are joint venture companies. B. Dormant company is formed and registered under this Act for a future project or to hold an asset or intellectual property. Dormant company has no significant accounting transaction. For the last 2 years, such a company or an inactive company may make an application to the registrar for obtaining the status of a dormant company. However, a dormant company is still required to have minimum directors, hold minimum 2 board meetings. C. One-person company, OPC, means a company which has person as a member. OPC requires one person who is natural person, who is citizen and resident of India. OPC enjoys the benefits of a private company. No board meeting is necessary. It encourages entrepreneurship. D. Private. A private company is 1. I. Minimum 2, except OPC, and maximum 200 members. 2. No minimum paid-up capital required. 3. Restricts transfer of shares. 4. Prohibits invitation to the public for subscription. Public is a company which I. is not a private company. 2. Whose minimum number are 7 and maximum is unlimited. 3. No minimum paid-up capital required. F. Small company means a company other than a public company. 1. Paid-up share capital of which does not exceed 50 lakh rupees, and 2. Turnover of which as per its profit and loss account for the immediately preceding financial year does not exceed 2 crore rupees. On the basis of liability of members. A. Limited company by shares. A majority of registered companies will be company limited by shares. In case of limited companies, liability of members will be limited to the amount unpaid on the shares. A. B. Limited company by guarantee. Here liability of each member is limited by the memorandum to such amount as he may guarantee by the memorandum to contribute to the assets of the company in the event of its winding up. As such companies are formed for the promotion of art, science, culture, sports, etc. Unlimited company. A company not having any limit on the liability of its members is termed as unlimited company. The members are liable for the debts of the company at the time of winding up on the basis of control. Government company. A company is said to be government company when 51% of the paid-up capital is held by the central government or by any state government, or partly by central government or partly by one or more state government. B. Foreign company. A foreign company is a company incorporated outside India and having a place of business in India. C. Holding and subsidiary company. A company which controls another company is known as the holding company, and the so-controlled company is known as subsidiary company. Others. A. Investment company. It means a company whose principal business is the acquisition of shares, debentures, or other securities. B. Non-trading company. This is also called association not-for-profit or charitable companies. The objects of these companies shall be promotion of commerce, art, science, sports, education, research, social welfare, religion, charity, protection of environment, or any such other work. C. Producer company. The object of these companies is one or more of the following: production, harvesting, procurement, grading, pooling, handling, marketing, selling, export of primary produce of the members, or import of goods and services for their benefit. The share capital of the producer company shall consist of equity shares only. Steps in formation of a company under Sector 7. Promoters. Pre-incorporated contracts. Registration. Promoter. According to Section 269 of the Companies Act, 2013, the term promoter can be defined as a person who has been named as such in a prospectus or is identified by the company in the annual return in Section 92, or a person who has control over the affairs of the company directly or indirectly, whether as a shareholder, director, or otherwise, or a person who is in agreement with whose advice, directions, or Instructions the board of directors of the company is accustomed to. Pre-incorporation contracts. Who is liable under the pre-incorporated contract? Company. Promoters or both are liable under pre-incorporated contract. Registration procedure. Application for obtaining Director Identification Number, DIN, from the Ministry of Corporate Affairs. Search for a company name. This step requires search of company name, and the availability of names can be checked at the website of Ministry of Corporate Affairs. MCA. Availability of company names can be checked at http www.mca.gov.in portal web login.dom set default property and mode 16. Application of proposed name. An application for proposed company name is to be filed with the Registrar of Companies, ROC. After approval for 21 days it can be reserved for 60 days for company already registered. Drafting of Memorandum of Association, MA, and Articles of Association, AOA. MA covers the fundamental provisions involved in the company's formation, and an AOA covers the rules and regulations governing the internal management of a company. Filling of forms with the ROC. The procedure for incorporation of company requires filing of some essential forms with the ROC, like Form Inc. and Form for Incorporation of Company, Form Inc. 22. Form for Notice of Situation of Registered Office, Form DIR-12. Providing information about particulars of appointment of directors, ROC fees and stamp duty payment. Thereafter, documents filed for incorporation of company will be verified by ROC. Pursuant to verification of documents, the ROC will issue a certificate of incorporation to the company. The company can commence functioning. A certificate of incorporation. Certificate of incorporation is issued when the registrar is satisfied with the documents provided. This certificate validates the establishment of the company in the records. Corporate Identity Number, CIN. The registrar also allocates a corporate identity number, CIN, to the company, which is a distinct identity for the company. The allotment of CIN is on and from the company's incorporation date. The certificate carries this date. Promoters are generally held personally liable for pre-incorporation contract. If a company does not ratify or adopt a pre-incorporation contract under the Specific Relief Act, then the common law principle would be applicable and the promoter will be liable for breach of contract. A company is not liable for the pre-incorporation contract when it come in existence, but under the arrangement of Section 15, H, and 19 of the Specific Relief Act 1963, company can take the rights and liability. The promoter, Memorandum of Association of a company is Section 256 of Companies Act 2013. Memorandum means the Memorandum of Association of a company as originally framed or as altered from time to time in pursuance of any previous company law or of this Act. Contents of the Name Clause, Registered Office Clause, Subject Clause, Liability Clause, Capital Clause, Subscription Association Clause. Forms of the forms available in Schedule 1 for different kinds of companies are as follows. The form in Table A applies to the companies limited by shares. The form in Table B applies to the companies limited by guarantee and not having a share capital. The form in Table C applies to the companies limited by guarantee and having a share capital. The form in Table D applies to unlimited companies not having a share capital. The form in Table E applies to the unlimited companies having a share capital. Process for change in name clause. Step 1. Notice of board meeting to be sent at least 7 days prior to date of. Step 2. Conduct BM and Pass B are proposing change of name of company and authorization to apply with registrar, central registration. Sender. Step 3. Apply two names in Run Web Service on MCA website. www.mca.gov.in. Step 4. Approval letter will be issued by registrar, CRC after analyzing. Application and name allocated will be valid for a PRD 60 days. From the date of application. Step 5. Issue notice of another BM 7 days in advance and conduct BM 4. Taking note of approval letter and calling of general meeting and approval of notice of such GM. Step 6. Dispatch notice of GM along with explanatory statement and amended set of MOA, at least 21 clear days prior to date of GM. Step 7. Conduct GM and pass SR. Step 8. File MB14WRTSR as per Section 117. Step 9. File Inc. 24 with Registrar. Step 10. Approval from the Registrar of Companies and issuance of new Certificate of Incorporation Inc. 25. When ROC approval is not required. If only addition or deletion of word private is happening. When application for change of name will not be allowed. Annual returns or financial statements due to be filed has not been. A company has failed to pay or repay matured deposits or debentures, or interest thereon. Process for alteration in object clause. Step 1. Notice of board meeting to be sent at least 7 days prior to date of. Step 2. Conduct BM and pass BR4. Heavy checkmark proposing alteration of object clause and considering amended set of MOA. Heavy checkmark calling of general meeting and approval of notice of such GM. Step 3. Dispatch notice of GM along with explanatory statement and amended set of MOA, at least 21 clear days prior to date of GM. Step 4. Conduct GM and pass SR approving object clause change and taking note of new Memorandum of Association. Step 5. File ME14WRTSR as per Section 117. Step 6. Approval from the Registrar of Companies and issuance of new Certificate of Incorporation. Process for change in authorized capital clause. Section 61. Step 1. Notice of board meeting to be sent at least 7 days prior to date of. Step 2. Conduct BM and pass BR4. Heavy checkmark alteration of capital clause, as required and considering amended set of MOA. Heavy checkmark calling of general meeting and approval of notice of such GM. Step 3. Dispatch notice of GM along with explanatory statement and amended set of MOA, at least 21 clear days prior to date of GM. Step 4. Conduct GM and pass ordinary resolution approving object clause. Change and taking note of new Memorandum of Association. Step 5. File E-Form SH7 within 30 days from the day of passing of or. Step 6. Approval from the Registrar of Companies. Shifting of registered office and approvals. Within same city, town or village only BR Form Inc. 22. From one city to another within state BR plus SR Form MD 14 plus. Inc. 22. From one ROC to ROC BR plus SR plus RD approval Form MGD 14 plus. Inc. 23 plus General 2 plus Inc. 28 plus Inc. 22. From one state to another state BR plus SR plus RD approval Form MD 14 plus Inc. 23 plus D 2 plus Inc. 28 plus Inc. 22. Process for change of registered office from one state UT to another state UT. Section 13. Step 1. Notice of board meeting to be sent at least 7 days prior to date of BM. Step 2. Conduct BM and pass BR4. Heavy checkmark alteration of registered office clause from one state to another. Heavy checkmark approval of notice of EGM and decision regarding conducting GM. Step 3. Dispatch notice of GM along with explanatory statement and amended set of MOA, at least 21 clear days prior to date of. Step 4. Conduct GM and pass SR approving change of registered office clause. And taking note of new Memorandum of Association. Step 5. File E-Form MGD 14 within 30 days from the day of passing of SR. Step 6. Publish an advertisement in 2 vernacular language newspapers. Not later than 30 days prior to filing of application before RD, and finalization of list of creditors, not older than 1 month. Step 7. filing of Form G2 within 30 days from publication, and then, after Form Inc. 23 with Regional Director containing application and requisite annexures. Also serve the physical copy at Office of Chief Secretary and RD. In case of listed company to stock exchanges and SEBI also. Step 8. Obtain the approval order from RD. Step 9. File E-Form Inc. 28 within 30 days from the date of approval. Step 10. Notice of BM to be sent 7 days prior to date of board meeting. Heavy checkmark board resolution for deciding or approving registered office address in new state. Step 11. Conduct BM and pass BR. Step 12. File Inc. 22 within 30 days of passing of BR. Alteration of liability and capital clause. A limited company can alter its capital clause by an ordinary resolution to increase or reduce its share capital by issuing new shares or by reducing the liability on share capital not paid up as has been prescribed under Sections 61, 62, and 66 of the 2013 Act respectively. If such alterations need to be notified to the ROC within 30 days of passing the resolution. However, intimation to the company law board is not necessary. Articles of Association, Sector 5, Content, Interpretation, Private Company, a share capital and variation of rights, preference shares, alteration to memorandum, a control of shares, shares held jointly, increase of capital, lien on shares, calls on shares and transfer of shares, transmission of shares, forfeiture of shares, alteration of capital, capitalization of profits, buyback of shares, issue of shares in kind, general meetings, proceedings at general meetings, voting rights and proxy, directors, proceedings of the board, chief executive officer, manager, company secretary or chief financial officer, common seal, borrowing powers, operation of bank accounts, dividends and reserve accounts, audit, winding up, secrecy, indemnity, execution clause, alteration of Articles Section 14. Section 14 of the Companies Act 2013 vests companies with power to alter or add to its articles. Alteration by special resolution, subject to the provisions of this Act and the conditions contained in its memorandum, if any, a company may, by a special resolution, alter its articles. Alteration to include conversion of companies. Alteration of articles. Include alterations having the effect of conversion of a private company into a public company, or a public company into a private company. Filing of alteration with the registrar. Every alteration of the articles and a copy of the order of the central government approving the alteration shall be filed with the registrar, together with a printed copy of the altered articles, within a PRD of 15 days in such manner as may be prescribed, who shall register the same. Doctrine of ultra vires. The term ultra vires means beyond powers. The memorandum of association of a company is a basic charter of the company. It is a binding document which describes the scope of the company, among other things. If a company departs from its MOA, such an act is ultra vires. Origin of the doctrine. The doctrine of ultra vires first time originated in the classic case of Ashbury Railway Carriage and Iron Company. 5. Riche, 1878, LR 7 HL 653, which was decided by the House of Lords. In this case, the company and MS Riche entered into a contract where the company agreed to finance construction of a railway line. Later on, directors repudiated the contract on the ground of its being ultra vires of the memorandum of the company. Riche filed a suit demanding damages from the company. Effects of ultra vires transactions. Doctrine of ultra vires. Void ab initio. Estoppel or ratification cannot convert an ultra vires act into an intra vires act. Injunction. Personal liability of directors. Any borrowing which is made by an act which is ultra vires will be void ab initio. It will not bind the company and outsiders cannot get them enforced in a court. Doctrine of constructive notice. Memorandum and Articles of Association are public documents. Section 399 allows any person to electronically inspect, make a record, or get a copy extract of any document of any registrar maintains company which before any person deals with a company he must inspect its documents and establish conformity with the provisions. However, even if a person fails to read them, the law assumes that he is aware of the contents of the documents. Such an implied or presumed notice is called constructive notice. Doctrine of indoor management. The doctrine of indoor management is also known as Turkin's rule. The doctrine of indoor management protects outsiders who have entered into any contract with the company by placing the parties in first place and company's policy behind it. Turkin's rule. Turkin's rule arose from the case Royal British Bank vs. Turkin. The facts of the case are as follows. The directors of the company borrowed a sum of money from the Royal British Bank, plaintiff. The company's articles provide that the directors of the company might borrow such sums with bonds as may be authorized by a resolution passed at a general meeting of the company. The shareholders of the company deny repaying the loan borrowed by the directors, as no such resolution was passed by the company in authorizing the borrowed sum as loan. The shareholders also claim that the amount was borrowed without their authority. The court held that the company is bound by the loan, whatever the company's articles provide. As director of a company is in the authorized position as per the outsider. Thus, the Royal British Bank is entitled in a position to recover its money lent to the defendant. The court observed that outsiders are bound to know the external position of the company but are not bound to know its indoor management. Exceptions to the rule. The rule of doctrine of indoor management is, however, subject to certain exceptions, where the outsider has knowledge of irregularity, suspicion of irregularity, forgery, representation through article, acts outside apparent authority. Corporate veil theory. The corporate veil theory is a legal concept which separates the identity of the company from its members. Hence, the members are shielded from the liabilities arising out of the company's actions. Therefore, if the company incurs debts or contravenes any laws, then the members are not liable for those errors and enjoy corporate insulation. In simpler words, the shareholders are protected from the acts of the company. Piercing the corporate veil. Piercing the corporate veil means looking beyond the company as a legal person, or disregarding the corporate identity and paying regard to humans instead. In certain cases, the courts ignore the company and concern themselves directly with the members or managers of the company. This is called piercing the corporate veil. Control rather than. Usually, courts choose this option when the case involves a question of ownership. Piercing the corporate veil. 1. To determine the character of the company. 2. To protect revenue or tax. 3. If trying to avoid a legal obligation. 4. Forming subsidiaries to act as agents. 5. A company formed for fraud or improper conduct or to defeat the law. Doctrine of lifting the corporate veil. There are two circumstances under which the corporate veil of the company may be lifted are statutory provisions, judicial interpretation. Statutory provisions. The Companies Act, 2013. A reduction in membership section 3A. If at any time the minimum requirement of members in a company as prescribed in section 3(1) is reduced below its statutory requirement, the remaining members need to fulfill the criteria of minimum requirement within 6 months. Otherwise, the remaining members shall be severely liable for all the debts taken after the expiry of 6 months from the date of reduction. Misrepresentation in the prospectus. Under sections 34 and 35 of the Act, there is civil and criminal liability for false representation in the prospectus. Every director, promoter, and every other Person who is in charge of the issue of prospectus shall be held liable for such misrepresentation, misdescription of names. Section 147. An officer of a company signs any document such as bill of exchange, promissory note, hundi, check, etc., on behalf of the company, and the name of the company is not mentioned in such document in a manner prescribed. Then the person signing shall be held personally liable to the holder of such instrument. Failure to return application money. Section 39. The minimum subscription as stated in the prospectus has not been subscribed within the prescribed time, the company must refund the entire application money to the applicants. If the company fails to do so, the directors shall be jointly or severely held liable to return interest and the application money. Fraudulent conduct. Section 339. If at the time of winding up of a company, it come into view that any business of the company has been carried on with intent to defraud creditors of the company, the person is or has been a director, manager, or officer of the company, or any other person shall be personally responsible without any limitation of liability for all the debts of the company as the tribunal may direct. Ultra vires acts. In case, if any action is done beyond the powers of the company, the directors or officers intended to do so will be held personally liable for their acts. Judicial interpretations. Corporate facade only in agency instrumentality. Jones versus Lipman. 1962. In the given case, Lipman transferred his property in the name of the company to avoid fulfillment of the contract. Therefore, he was held liable for the non-fulfillment of the specific performance of the contract. Lipman and the company shall be treated the same by creating an exception to the principle of corporate personality. Public Policy Re RG Films Limited, 1953. In this case, the Board of Trade refused to register a film in India in the name of a British company. The film was actually produced by an American company in the name of a British company, and this was in conflict with the public policy. Acts evasion. Sir Dinshaw Manakji Petit, 1927. In the given case, the assessee divides his income into 4 parts to reduce his tax liability. He formed 4 companies as a means of avoiding super tax and did no business at all. Therefore, the court disregarded the corporate entity and held the assessee liable for tax evasion. Daimler Company Limited v. Continental Tire and Rubber Company, Great Britain, Ltd. This is an instance of determination of the enemy character of a company. In this case, there was a German company. It set up a subsidiary company in Britain and entered into a contract with Continental Tire and Rubber Company, Great Britain, Limited for the supply of tires. During the time of war, the British company refused to pay as trading with an alien company is prohibited during that time. To find out whether the company was a German or a British company, the court lifted the veil and found out that since the decision-making bodies, the board of directors and the general body of shareholders were controlled by Germans, the company was a German company and not a British company, and hence it was an enemy company. Prospectus. In company law, prospectus plays a significant role, where it contains all the material information, general, financial and statutory, of the company, i.e., prices and shares detail of the specific company, which helps the public who wishes to buy a share in that specific company. As the prospectus is a legally mandated document, it must be registered under Register of Companies. Definition of prospectus. As per dictionary definition, prospectus means a prospectus is an offer document or information booklet issued by a public company used for inviting offers from the general public for subscribing of shares. According to the Companies Act 2013, prospectus is defined under Section 270. Prospectus can be defined as prospectus means any document described or issued as a prospectus and includes a red herring prospectus referred to in Section 32 or shelf prospectus referred to in Section 31 or any notice, circular, advertisement or other document inviting offers from the public for the subscription or purchase of any securities of a body, corporate. Essentials for a document to be called as a prospectus. To consider the certain document like a prospectus, following essentials are. The document should invite the general public for the subscription of shares. It must be made to the general public. It must be made by the company. It should relate to shares, debentures, and such other information pertaining to the company. Every public company must issue a prospectus, a statement in lieu of prospectus when the private company is converted onto a public company. Issue of prospectus. The issue of the prospectus is defined under Section 26 of Companies Act 2013. If a company does not issue prospectus before 90 days from the date from which a copy was delivered before the registrar, then it is considered to be invalid. If a prospectus was issued in contravention under Section 26 of Companies Act 2013, then the company can be punished with a fine of 50,000, which may exceed up to 300,000. Kinds of prospectus. Kinds of prospectus are red herring prospectus, shelf prospectus, abridged prospectus, deemed prospectus, shelf prospectus. Provisions related to shelf prospectus has been discussed under Section 31 of Companies Act, issued by the public financial institutions, company, or bank. When a shelf prospectus is issued, then the issuer does not need to issue a separate prospectus for each offering he can offer and sell, without issuing a further prospectus, as it is valid for 1 year. The company that is filing a shelf prospectus is required to file the information memorandum. The information memorandum consists of all the facts regarding the new charges created, what changes have undergone in the financial position of the company since the first offer of the security or between the two offers. Red herring prospectus, Sector 32. The prospectus which lacks the complete particulars about the price and quantum of the securities offered. RHP is issued prior to the issue of prospectus when it is proposing to make an offer of securities. It may give a band or minimum figures of issue size and issue price. A red herring prospectus needs to be filed with the registrar at least 3 days prior to the opening of the subscription list or the offer. Abridged prospectus. A abridged prospectus Section 2(1) means a memorandum containing salient features of prospectus. It is prepared as per format specified by SEBI. Every application form issued to subscribe securities shall be accompanied with abridged prospectus. The abridged prospectus and the share application form should bear the same printed number. Deemed prospectus. Provisions related to deemed prospectus has been discussed under Section 25(1) of Companies Act. It provided that any company to offer securities for sale to the public allots or agrees to allot securities, the document will be considered as a deemed prospectus through which the offer is made to the public for sale. A company is deemed, presumed, to have allotted or agreed to allot securities to issue house for sale within 6 months. Civil liability for misstatement in prospectus. Criminal liability for misstatement in prospectus. Procedure of private placement. The Companies Act 2013 has formulated Section 135 and is landmark legislation that makes Indian companies answerable to the government about their CSR expenditure. India is the first country to make the incorporation of corporate social responsibility activities mandatory for qualifying companies. It is a remarkable step towards growth, overall development and humanity. Kundi. Be it a private sector company or a public sector company, corporate social responsibility CSR has to be adhered to by all listed companies. If a company falls in either of the following criteria for compulsion, they need to form a CSR committee. Companies that has a net worth of 500 rupees crores or more, or that have an annual turnover of 1,000 rupees crores or more, that generate a profit of 5 rupees crores or more, The CSR committee and policies. The qualifying companies are required to form a CSR committee. They are needed to spend at least 2% of its average net profit for the 3 previous consecutive financial years on CSR initiatives. And mandatorily, a CSR committee has to be formed by the qualifying company. It also has to appoint at least 3 board of directors. Board. This committee is responsible for preparing and recommend to the board a policy and a plan that will specify the CSR activities to be undertaken, CSR policy. They would also suggest and protect the amount of expenditure to be incurred on the activities referred, and monitor the implementation of CSR policy and activities. The board will analyze the recommendations and suggestions made by the CSR committee and support the CSR policy and activities of the company. Types of CSR activities under Schedule 7. The following are the types of CSR activities in India that the qualifying listed companies under the Companies Act 2013 can contribute to. I. Eradicating hunger, poverty and malnutrition. 2. Promoting education. 3. Promoting gender equality. 4. CSR initiatives related to the environment. V. Protection of national heritage, art and culture. Kundi. I. Measures can be taken towards the benefit and support of armed forces veterans, war widows and families. 7. Contributions to the Prime Minister's National Relief Fund or any other fund set up by the central government for welfare, development and relief of the scheduled caste, tribes, other backward classes, women and minorities. 8. Contributions or funds provided to the development of technology located within the central government approved academic institutions. 9. Contributions can be made towards rural development projects and slum area development. Companies in India doing CSR activities. ITC has been doing impactful CSR activities in India for years now. Has educated about 329 children through its 2,334 supplementary learning centers. They have also supported, empowered about 15,378 women members through 1183 self-help groups. Tata Power. Tata Power has made it its topmost priority to empower women through its self-help groups in Kutch region of Gujarat. This initiative provides financial aid and loans for housing, purchasing cattle, capital, for business, education, marriage and medical purposes. Infosys. Infosys is one of the early adopters of corporate social responsibility. Have takes up projects like the restoration of water bodies in Karnataka and metro station construction in partnership with Bangalore Metro Rail Corporation Limited. Also, they are making a contribution in sports through their Gosports Foundation. Their CSR initiative also includes a relief fund for Tamil Nadu, Karnataka and Kerala. Reliance. Reliance has taken up the initiative of securing the life of villagers of Balnagir district. They have a life insurance program for them. The Education for All initiative was launched to provide access to quality education in India to everybody. They work to protect the right to education of underprivileged children, girl child and differently abled. Also contribute to disaster relief funds. Tata Steel. Tata Steel, for the last 100 years, has been committed to the social development and upliftment of Jharkhand. The agenda of their CSR committee is to improve the quality of life of the communities it operates. They also launched a train called Lifeline Express in 1991, a running hospital that serves the needy regions of India. They have done numerous AIDS awareness programs. Over the years, Amul has contributed to rural health and development. Through Tribhuvanda's foundation, they have also established Swarn Jayanti, Gram Swarozgar Yojana, a holistic self-employment program in Kheda district. They also successfully run tree plantation drives, blood donation camps and rural sanitation programs. They also provide scholarships through their Amul Scholar schemes. Cafe Coffee Day. At the beloved coffee shop, Cafe Coffee Day employs 50 speech and hearing impaired people at their various outlets as staff. They do this as a part of their CSR activity as a move towards equal employment. They call them the Silent Bruumtas. CCD also has tie-ups with NGO Enable India to empower differently abled people. Their biggest CSR initiative is the SVGH Vocational Training College in Chikmagalur, Karnataka. Panji Shiksha, Padhaga India is a crucial part of Procter & Gamble's CSR. The Shiksha initiative has, till date, helped about 280,000 underprivileged children to get access to their right to education. They have also built and supported over 140 schools across India. Kandi Wipro. Wipro makes its contribution to education and upliftment through Wipro. Not just education, Wipro addresses disaster relief and rehabilitation, and health and wellness programs for the needy as well through Wipro. They have also launched Wipro I that promotes ecological sustainability in its operations. DLF is India's largest real estate company, initiated in the interest of educating children of construction workers. Swapana Sarthak Informal School was established. They have also set up employable vocational training centers under the banner of DLF Life. They've also set up DLF Inspire to improve the quality of life of underprivileged children.